Esimu eso senegalo okuva mu
awakuba webifaananyi.
Bulaba yingo nate atera biko.
We shall live in peace.
I'm going to I'm probably at the battalion. Captain Dennis Ola.
Chief Secretary, together with my young friend, Joseph John Hendo, also Chief Secretary, appeared for prosecution. The accused person of the court, and I'll let my senior colleague,
Please, Your Worship, my name is Elias. Appearing together with my land friends. That is Kizza, Wanda Samuel Leonard, Univia Scovia, Kato Tumusime, Bayan Lunawe, Farouk Kamreke, Second Yako Abubakar, Cyrus Ogur, our concern. Some of our colleagues are not here. Some of our colleagues, part of the defense team is not here, Your Worship. Reason, we got very short notice because we received the production warrant when it was coming to 6 p.m. yesterday. And the team leader, that is Senior Counsel Martha Karua, had just returned to Nairobi. She was here on Wednesday. We requested the sitting magistrate to accommodate us this week, either yesterday or today. I said, the diary of the court is full, and that the instruction we had was to adjourn this matter to early June. We put it down. Mr. Please come and say there was no way this matter would be had it. I mean, it would be fixed again this week. So that would have enabled our senior colleague Martha Karua to stay. If indeed Your Worship who had been accommodated for this week, she would be here to lead the team. Now, shortly after she had returned to Nairobi, they will get summons, rather production order. And to make matters worse, Your Worship, we don't know why we are here. We have no idea. We could not even prepare anything. It's ambush. Total unacceptable, Your Worship. We don't know how court was moved, because there must have been a formal application to move court to issue production order, either by a letter indicating the reason why court should be convened today. Because the matter was adjourned to 29th next Thursday. So, Worship, we wanted to pure record that particular matter, that this ambush is totally unacceptable and we take exception. Regarding the atmosphere in the court, is not conducive for dispensation of justice. Your Worship, under Article 28 of the the Constitution, one of the key tenets of fair trial is public hearing. Public hearing. But the atmosphere, the whole environment here, the worship, is not in any way concomitant with the dispensation of justice. On Wednesday, Your Worship, we struggled to get at least an opportunity for the loved ones of the accused persons to have an interface, an interaction. Even after it had been granted, we had to go through rigorous processes of realizing that constitutionally guaranteed right of access to documents within the precincts of court here. It was a tug of war. The prisons authorities here were too harsh. Very restrictive. Even after the court order had been given, issued, that we should have that right or opportunity to interface or interact with the accused persons. And shortly after that interaction, some members of the public were arrested, actually were kidnapped from the precincts of court. These were Katongole Uma and Kamira Abdul. They were picked by plainclothes operatives who could not be easily identified. At the very best, I can describe them as goons because they were here, they were not in uniform, they could not identify themselves, and the reason why they were harassing people here, and they picked and whisked them away. So, Your Worship, we pray that you take charge. We pray court premises so that members of the, and I'm sure Your Worship, even as we are seated here, several operatives are within the precincts of court. Are within actually the court. And finally, Your Worship, before you stepped in here, there was again a scene, Scott. There was a scene here where members of, because he belongs to the yesterday political party, and he's a national leader, and there are people who are interested in these proceedings and want to attend. But this kind of treatment is making it difficult for people to be here to witness the court proceedings. And I was telling you this morning, there was a scuffle, there was a scene here as security operatives were unleashing terror and brutality against law-abiding citizens who are here to witness court proceedings. We therefore pray that Your Worship will be pleased to issue directives and orders that will guarantee protection of the rights of members of the public who have got the right to be here. We do so pray, Your Worship. And again, for the record, Soka Simon for every is with us. So much.
My senior leader has said, especially the concept of fair trial, and the state is
calculation to exclude the lead lawyer of Besigye and Tare, Honorable Karwa Martha, Senior Counsel. It is illegal and would violate the right to fair trial contrary to Article 28, Clause 1, as well as Clause 3, paragraphs D and C. Your Honor, you are not, the law does not allow you to preside over a trial that violates the fair hearing of the accused. And we are making this complaint not only pursuant to the Constitution, but also the relevant sections of the Human Rights Act, namely sections 7 and 11. But because, Your Honor, this is a non-derogable right under Article 44, paragraph C, I think this court should be pleased to refer this matter to the High Court to pronounce itself on whether we can proceed without the lead lawyer of Besigye and Tare, so that this court can be guided from similar gimmicks or repressive gimmicks by the state. May this be the last time, yes, so that this honorable court can be guided on how to handle similar gimmicks by the state, designed to choose lawyers for their choosing. By orchestrating ambushes in forms of impromptu trials, impromptu appearances, court appearances like this one. This is an impromptu court appearance because even the lawyers in Uganda, some of them are still responding to this production warrant. Some of them, I had to call them and they were asking, oblivious of this court proceeding. So, in order to enforce Article 28, we are praying that this matter be referred to the High Court pursuant to the Human Rights Enforcement Act, sections 7 and 11, so that this fair hearing, this egregious fair hearing infraction by the state is addressed once and for all, because it is not the first time that the state of Uganda has tried to technically, but of course progressively exclude Honorable Nakawa from representing her clients in Uganda. The first initial attempts were to deny her a PC. The third was to delay it. The last time she got it, she presented it when we appeared for the first time, and now when she needed to appear and beg and implore this court last time, because she should be the one speaking, I shouldn't even be doing this speaking. The state claimed that it would not be here. The state claimed in open court that they would not have any time this week.
But I think you should be another address by
my Lord, I will put rest that point here and emphasize the second point of we are not safe in this court before you, both as lawyers and as members of the public who follow these proceedings. We need your protection from goons some of whom are in court now as you write, Your Honor. In that corner, some of them are there. Some are in that corner. So, their unapproved conduct, Your Honor, includes after court arresting some of these people here. Their unapproved ignominious conduct includes arresting members of the public from here. They don't even wait to get out of court premises. They arrest Ugandans in court premises. It's about time judiciary protected Ugandans, because courts are sanctuaries of justice. They are not scenes of arrest. They are not torture chambers. But even this morning, there were blows in this court before it started, before court started, because there are some fools who believe that they can come to court and not be filmed. Most of that. There are some ill-educated persons, Your Honor, who are oblivious and ignorant about the right to a public hearing. They think that they can be here and be protected from the camera without a court order. It is that level of ignorance that we have to confront every time we come to this court. Once again, that atmosphere is not safe, and we need the express protection of this court, because that does not require high court. It's not it is something that the court can use its inherent power to defend the public. So great.
For those taking recordings, ensure that at least you don't capture me.
First of all, Your Worship, Senior Counsel raised the issue. We prayed for today. Or yesterday, which is very true. I wish to add that even prosecution wanted yesterday or today. We never caused that in any way. It is upon that background that we moved this court. Prosecution moved this court. By way of a letter, which is from court record, to have this matter entertained today. It is also true that they were served yesterday to be here. That also speaks to the courteousness of the prosecution. Because this is a prosecution's case at this level. On the issue of senior prosecution is not going to be held back because of the absence of senior counsel matter. She should be ready to be present in Uganda full time advance before this court. Because she never even informed the court advance before this court. Because she never even informed the court that she's a resident of Nairobi. We all respect the senior counsel, Elias Lupao, and other lawyers. Our argument arguments that they are fully represented. And then I think of referring this matter to the High Court. But even the record is very clear. This matter started on the 21st of February 2025. Senior Counsel Martha came in recently before this court. Does that show that the accused persons were not ably represented before? Does that speak to that? She appeared that I withdraw that. Let me proceed. I have read it. But my argument is that the accused persons have been represented all through, and therefore the absence of senior counsel Martha should not be an issue and cannot be used as a basis to have this matter referred to courts, because there is nothing available for a high court to hear in that respect, because this is a preliminary trial. It is not a substantive trial. We therefore invite court to treat that application by my colleague Elmichis as redundant. It is actually aimed at wasting this court's precious time. And prosecution has been on record, Your Worship, previously for lamenting on how defense is investing in wasting time in this matter. Your Worship, we are not, as prosecution, aware. We are not aware of the previous arrests which were made. I heard my senior colleague Elias Muswabu say some people were arrested. Within the court premises. Your Worship, prosecution does not support that. And prosecution is also not aware of the scene that happened in court this morning. And we do not know and not I don't know whether my senior colleague is submitting the effect that is a statutory office against the court attendant or the court user. With that, we do not know. And I think I pray that court considers that as redundant, although it is imperative to emphasize the point of maintaining security and order in this court, in order for all of us to have a proper environment. My colleague Kizza alluded to the fact that lawyers and the public are not safe. I don't know whether my colleague has been attacked himself. But as far as I know, none of the advocates on either side has been attacked. But if anything of that sort happened, it is not something that prosecution supports. The prosecution supports the rule of law at all times. But we also appeal to the court users, other court users who are not security officers, to ensure that they behave Because you have been singing here. We have not complained. You have been singing how Vilifumka will die, how his wife will die, and how his children will die. So we are calling upon your worship. It was on record. It has been captured. So we are calling upon that much as defenses are making that, they should also prevail over their own people. They should make sure that their house is put. Because they came here and sang those songs which are pro the accused person, we have no problem. But when you bring in the songs of the president, Muhoz, and then you bring in Vili from Karucha, who is not a political, who is not political in any way, it's not good, especially for the court users. I should have brought in that if council hadn't brought in that issue, the safety of the lawyers. We are also not safe. Represented in court. You can imagine this fleet of lawyers only to claim that the only person who is going to move this court is Martha. Yes. This matter was called today because we are ready to proceed. We submit.
Of the state moving this honorable court to secure the production warrant, that there is a letter of record. It's most unprofessional for one to write to court and not share a copy of the communication you have filed on record with the opposite side. Very unprofessional. Up to now, up to this particular moment, Your Worship, we have not been given, we have not been favored with a copy of that letter. That shouldn't be taken lightly. And it's not a favor. It's a right. That whatever pleading you put on record, serve a copy on the opposite party. That's a command of the So we are really taken aback by that submission. It shouldn't have come from the chief state attorney. That they've moved the court and they never served us. It's an absurd, Your Worship. Secondly, Your Worship, you insinuated that indeed actually they had no objection to the adjournment of this matter this week, actually that they were in agreement with our prayer that this matter be fixed either yesterday or today. I hope he is also in agreement with the reason why we moved the court to have it heard today. Because the reason we wanted this matter to be entertained yesterday or today is on record, well captured on record. To give effect to the letter and spirit of Article 23, which dictates that once an accused person has been on remand for a period of 180 days, the next course of action will be mandatory bail. So if that is the reason we are here and is in agreement with that, then we have no problem. If we are here for a different reason, and that he moved the court to make other prayers, we have issues with that. If the court was, this session is about that application, that the accused persons be released because they have spent more than 6 months on remand. And the command of Article 23 is very clear, ready together with Section 70 76 of the MCA. Your Worship, if I may, for the record purposes, read this section 76. Restriction on period of pre-trial remand. If an accused person has been remanded in custody before his or her trial commences.
But Your Worship, before my senior colleague, you don't do this. There's nothing like that that came up. We never talked about that application is talking about. Neither did he even bring it up when he was actually making his first submission. So I think it is my submission that that is irregular. Let him stick to my response.
Your Worship, this is not an LC court. There are procedures, there are rules. If I may be permitted to make my submission, and if you so wish to respond, you will know what to do. You can apply for leave.
But you cannot raise new issues when I'm seeing.
It's not an
It's
LC.
fine. Let him submit the issue.
Your Worship, I was reading that particular provision. If an accused person has been remanded in custody before his or her trial commences, A, in respect of any offense punishable by death for a continuous period exceeding 180 days, or B, in respect of any other offense for a continuous period exceeding 60 days. The magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in section 75, and so on and so forth. It continues. Unless, maybe let me complete it. Unless A, he or she has prior to the expiration of that period been committed to the High Court for trial, or the magistrate is satisfied that it's expedience for the protection of public that he or she should be released from, and so on and so forth, Your Worship. So, the reason we have requested for this day, Your Worship, that's what I was justifying, is to respect, give protection, and to enforce this particular provision. Section 76, read together with Article 23 of the Constitution, because they had spent more than 60 days, more than 180 days on remand. That is 6 months. And the command of this particular provision that once that period has elapsed, the magistrate, before whom they first appear, before any other action is taken, it's the issue of the release which has to be considered. Once the period of 6 months has elapsed, the first appearance before magistrate is about this. So we cannot do any other business today. And that is the reason we had asked the court to accommodate us this week. I am glad he said he was in agreement with that. So if that's what brings us here, we are ready to proceed and make our case. That's the argument I was making in response to the issues he had earlier raised, that he was in agreement with us for a fixture of today. Then about senior counsel Nakawa not being part of the legal team today, it's very, very absurd to hear the state attorney make such outlandish statements. And we take exception. That our presence here is of no relevance, is inconsequential. Your Worship, the command of the Constitution again. You look at the provisions of Article 23 and Article 28. The liberties of an person to choose their ways is well guaranteed under the Constitution. It's not about the competence or incompetence of those who are here. No. And the court wouldn't delve into that. To say, are those who are here are competent enough? No. It's about the right of an accused person under the Constitution to choose their lawyers. It's about giving respect to that particular provision, enforcing it. For heaven's sake, the accused persons are not about to disclose the reasons why they chose Senior Counsel Nakawa to lead the team. And the state did not allocate themselves that duty of making a choice for them. To suggest that Martha Karua should stay here permanently is equal outrageous. It's on record she was given a license to handle only one case this way. It's a matter of logic. I don't even need to cite any law. It's a matter of logic that a person who is outside the jurisdiction of this court cannot stay here to handle a case which is not being heard on a daily basis. And the reason we had asked court to adjourn to either yesterday or today is a question of convenience. We thought this is just a simple matter. It's basic. One would appreciate it. But one will not stay here and wait until 29 when you are a resident of Nairobi. That is our picture of singing. I don't know how it is, the future is here. Your Worship, before court commences, this is a court meeting. Court means the setting we are having right now. No one, nobody in the gallery has attempted to sing in the court or before court. You expect there's no way you're going to there's no way you're going to divorce politics from a matter which is politically motivated. That we have sung about him, about Seveni Ngozi. No one can speak about it. I mean, as long as it doesn't offend the law. So, Your Worship will be on record. If one said, look what you will die, that's a given. That's a given. It's divine ordained that we must judge that. But if it offends the law, then there are procedures you have to follow. Under the law, you don't simply use goons, hoodlums, to kidnap members of the party. No one has been charged in any offense. No one has been in any way presented before court, here or anywhere, in relation to what you are talking about. So you just pick people, brutalize them, and dump them the way you do fit. Your Worship, court should tolerate that. So, in a nutshell, Your Worship, we make our prayer for the liberties of the accused persons under the provisions of Article 26, 23, and Section 76 of the MC. Article 23 of the Constitution and Section 76 of the MC. And the state shouldn't be allowed to proceed with any other matter apart from this issue. That is our prayer, Your Worship.
And about the nature of this being a preliminary trial, that is a given, no one is denying it, but even at the level of a preliminary trial, the right to a fair hearing is sacrosanct. It cannot be suspended by an overzealous prosecutor in a case that is nothing more than political persecution and judicial harassment of a horrific, a hero of Uganda. I want to also go specifically point number 2 from section 7 of the Human Rights Enforcement Act, which reinforces section 76 of the MCA that my senior brother alluded to. I will emphasize there are just a few subsections. Section 7, subsection 1 is succinct, where in any proceedings in a subordinate court, any question arises as the violation of a fundamental right of freedom, the magistrate shall refer the question for determination by the High Court. That is subsection 1. Subsection 2, where a human rights matter arises in any proceeding before a magistrate's court, the court shall immediately stay proceedings in the matter and first determine the human rights issue raised. And especially then subsection 3 relating to the liberty of the accused. A magistrate presiding over proceedings referred to above may stay the proceedings until the reference is determined and may, in the case of a criminal trial, grant bail the accused person. Of course, 4 says that the court shall dispose of the matter in accordance with what the court says, and the High Court is also given a timeline within which to operate according to subsection 5. So everything points to that today it's only the bail of the accused persons that this court can handle, and that the court's hands are tied. 1, to refer the matter to the High Court for fair hearing, and as they refer it to grant bail in the terms and following section 76 of the Magistrates Court Act. I will not respond to the whereabouts of the prosecution. Thank you.
And a little more emphatic. First, I associate with the submissions of Lord Mayor Elias Lukwago and the submissions of Errol Kizza. The state informed court that it was an agreed position on the 21st. Your Worship, on the 21st of May this month and this year, the sitting magistrate informed court that he only had 2 dates of which he was guided to adjourn his case. That was on the 2nd and the 5th of June. The defense prayed for today. It was the decision of the sitting magistrate that the matter be adjourned to the 29th of May. The state has informed that there is a letter on record. I want to be clear on this, that I do not, and we do not have a copy of that letter. But it is a command still about legal representation and adequate facilities to represent. I don't have the letter. This speaks loud that I do not have adequate facilities for fair representation of A3. It is just fair and in the interest of justice that the matter be adjourned to any other date. By the way, if you incline not to adjourn, actually when they informed me that Ola was coming to court, I thought I was coming to take Ola home. If it is the case, I'll be happy to take Ola home. Short of that, Your Worship, I pray that the matter be adjourned to a date where I can adequately prepare to represent Ola today. As it is today, I'm not ready to represent him, for I do not know why we are here. I was ready for the 29th to represent Ola adequately. I so pray.
If it's granted for you to respond to only the new issues that have been raised.
Much obliged. Your Honor, in regard to the period spent for the man, 25, and today is only the 23rd of May, 2025. And an arithmetic calculation leads us to a period of 4 months, and not the 180 days that our land. My Lord, 3 months, and not the 180 days as alluded to by our senior land friend, Honorable Kwame. Your Honor, be that as it may, even if the accused persons have clocked the mandatory period, according to guideline 9, which I'm going to read out verbatim, mandatory bail for offences triable by High Court and Magistrates Court. Where an offence is triable by the High Court as well as by a subordinate court, if a person has been Your Honor, sorry, it is guideline 10. According to court, when the offence is before this honorable court and is triable by the High Court, the application can only be made before a High Court judge and not before you, Your Honor. In other words, the issue of mandatory bail in a capital matter cannot be raised before this honorable court. My Lord, we pray that you dismiss. We pray that you dismiss or disregard our senior land friend's prayer in regard to entertaining the bail application, my Lord. We so pray.
That issue of mandatory, I think my senior colleague just brought in as a bonus for airtime, because it was not an issue which he brought in the first place. Secondly, the defense has no duty to dictate what this court has to do with the prosecution's case. It was erroneous for my senior colleague to submit that they can only allow anything to do with the application for mandatory period of time. It is the prosecution that moved this court to have the matter in court today. Before we even actually bring to the attention of court as to why we made the application, defense. And this is what I've been saying, Your Worship, that we are being arms twisted on several occasions. And this is one of the ways. We wanted to be in court today, defense is dictating. This is the spirit which defense is using to ensure that this matter is not heard at all. We therefore invite this court to, first of all, only regard the reason as why we made the application and disregard the application made by my senior colleague. This court should be heard or should be seen moved by prosecution on the reason as to why this application was made, the production warrant, to have the matter today. Otherwise, we shall waste the entire day speaking about that. That issue can be brought when prosecution is actually unveiling the reason as to why they prayed for the production warrant. We saw.
Now they have delved into the court being formally moved. Now they indicated that the ones who are moved in court. And we said, okay, if we are here to entertain the application for mandatory bail, we are ready to proceed. And we are waiting for the pronouncement of court on that matter, that proceed with your application for mandatory bail, then we make it. Now, they appear to have responded to the application. Before we may we be permitted now to also, I don't know, if we could be given leave, because they are raising issues of regulations, we need to address court on issues of regulations.
Defense has raised several issues, which court has to address. Can I make a ruling on this as it is?
And if court is going to make a decision on the same, it would only be fair that we raise some issues in regard to that particular matter. Even if it's only that issue alone. Just on the case. Not yet.
Can I rule on what is here?
Most of
Bearing in mind what you submitted.
Most of that.
And then the submissions on the issues raised. The issues raised majorly are in regard to legal representation as provided for under the Constitution. The defense has raised an issue that the two accused persons are represented by counsel Nakawa, who is currently in Nairobi, and ought to be here to represent her clients. This court is mindful of the right to legal representation as provided for under the Constitution of Uganda. The accused persons are before court and are ably represented by lawyers, although they said that counsel Martha Karua is a lead counsel. Whereas this court appreciates her role as lead counsel, I believe that the team of lawyers in court present can ably represent the accused persons for today's hearing. This court thus believes that the accused right to legal representation is guaranteed. This court thus finds no basis to refer the matter to High Court under the Human Rights Enforcement Act. Counsel Kwago has submitted that they are in court today to make an application for release of the accused persons, and as such, the submissions made by the prosecution are done prematurely. The accused having appeared in court on a production warrant, the prosecution should proceed to make its application or proceed with the production warrant, the reason why it was issued, and thereafter the defense may make the prayers they intend to make in regard to the liberties of the accused persons. This way.
Your Worship, the lawyers don't have instructions from us to proceed in the absence of their leader. I don't know where that leaves us. Because we appointed the Honorable Mark Karua to come from that far, very cognizant of the competence, the availability of our current team that we have. That she has a special role for me and him, that we have had to incur that great cost to get her here each time. Worship, our lawyers definitely don't have instructions from us to proceed in the absence of our legal counsel.
Your Worship, as our client has submitted here, we act on instructions.
Our former clients.
Our client, as far as the matter is concerned. But today, the matter where we have instructions is supposed to come up on 29th of this month. So we appeared here on Wednesday this week, and that matter was adjourned 29th. As for the proceedings of today, where we do not even have a copy of the letter, which is moving in court to proceed, where we have no idea as to the substance of what is going to be next. We are also in your worship.
From the time when this court convened, it was on record the accused person A1, A2, and A3 were in court. It is also on record that when they were in court, Lord Mayor, Senior Lord Mayor, Lupao, introduced himself and his entire group as lawyers representing the accused person. And the accused person was listening. I'm submitting. If there was anything to do with not instructing them to do anything in the absence of Martha, then he should have raised it at that time. How did they come to represent him in this court today without instructions? This is what we've been talking about: arm twisting prosecution, delaying, frustration. And then they start lamenting 6 months. Prosecution is making a headway into investigation. It is expediting the process. Defense is holding it back. And then they come and submit how the rights of the accused person have been infringed upon. I think this is a duty of both prosecution and defense to ensure that we have an expeditious process in this matter. Cite other rights, and then you leave the right to speedy and expeditious trial, which we are talking about. In any case, there has not been any substantive reason as to why the absence of Martha can stall this matter. This is a prosecution case. Looks like defense is taking it over. Now court has to dance the tune of the defense. We are being held back. Court has already made a ruling on that. If A1 retired Colonel Kizza Besigye knew that he had that in mind, he should have raised it even before this court made that ruling. We are submitting that that is an abuse of the process. It amounts to an abuse of the court process, which is detrimental to this matter, to why this matter is in court. First of all, this is at a preliminary stage.
Let me just stop right there. Make the ruling. So you made the submission after my ruling. On the fact one.
I hardly know the gymnastics and procedures. There were many things that were being talked about here. I do not know whether when had to, when I heard you say that the matter can continue without her. I did not know that it had come to that. And I have to alert you about our decision. So if prosecution wants to continue without us being represented, there's nothing to be done.
Your Worship, it's not factually correct with all due respect to Your Worship. Why, Your Worship, we clearly indicated to court that we had instructions to proceed with an application for mandatory bail. We have no instructions to proceed with a matter which is not known to us. We can only get instructions